The ranch sat exactly where I wanted it to, miles from the nearest subdivision, bordered by open land and a two-lane road that rarely saw traffic. Rolling pasture, a weathered fence line, and a farmhouse that had seen better decades, but still stood solid. When I bought it, the listing made one thing very clear: outside HOA jurisdiction. That wasn't a bonus.
It was the reason I signed.
I dealt with HOAs before. Committees, letters, fines wrapped in polite language. This ranch was my exit from all of that. No architectural approvals. No community standards. Just land, responsibility, and silence. The closing process was clean. The title search was thorough. The survey clearly showed the boundary line ending well short of the nearest HOA-controlled neighborhood. I paid extra for an independent legal review, because land doesn't forgive assumptions. When the keys hit my hand, there was no question. This property stood on its own. For the first few weeks, nothing happened. I repaired a section of fencing, cleared debris from an old barn, and got used to mornings where the loudest sound was wind moving through grass. Neighbors waved from a distance. No one crossed the fence line. It felt like freedom had an address. Then the letter arrived. It was thick, official, and marked urgent. HOA letterhead. Not my HOA, their HOA. The one whose boundary ended a good half-mile away from my driveway. The letter stated that my property was subject to mandatory association fees due to shared infrastructure and access considerations. It demanded immediate payment of $25,000 in back dues and compliance assessments. At the bottom was a line that turned my stomach cold. Failure to comply may result in eviction proceedings. Eviction. From land I had legally purchased. Outside their jurisdiction. With no covenants tying me to them. At first, I thought it was a mistake. A clerical error. Someone confusing parcels on a map. I called the number listed, expecting a quick correction. I was wrong. The woman on the phone didn't sound confused. She sounded rehearsed. She told me the ranch benefited from proximity to the HOA community and therefore fell under extended governance. When I asked her to cite the legal basis for that claim, she deflected. When I mentioned the survey, she dismissed it. When I said the property was explicitly outside HOA boundaries, she said, "That's not how we interpret it." That was the moment I understood this wasn't an error.
It was a test.
A few days later, a second letter arrived. This one more aggressive. It outlined a payment plan, included interest calculations, and warned of legal escalation if I failed to respond. They had already decided I owed them money. They were just waiting to see if I'd panic.
I didn't.
Instead, I pulled every document from closing.
The deed.
The survey. The county's zoning maps. The original subdivision filings from decades earlier. The paper trail told one clear story. The ranch was never part of the HOA. Not historically. Not contractually. Not geographically. Still, the pressure increased. They sent a compliance officer to the fence line. He never crossed it, just stood there, clipboard in hand, taking photos like proximity alone gave him permission. He left a notice taped to the gate, warning me about unauthorized land use. That's when the threat became real. They weren't bluffing. They were building a narrative, one that relied on intimidation, complexity, and the assumption that I'd rather pay than fight. What they didn't know, what they never bothered to ask, was that I wasn't afraid of court. I was prepared for it. And once they filed their claim, demanding $25,000 or eviction, they unknowingly stepped onto ground where confidence doesn't matter. Only facts do. That was the day the ranch stopped being just land. It became a case. The lawsuit arrived in a thick envelope, served by a courier who looked just as confused as I felt insulted. The HOA wasn't asking the court to clarify boundaries or resolve a dispute. They were demanding enforcement. They claimed my ranch was subject to their authority due to implied inclusion and functional dependence. It was bold, almost impressive if it hadn't been so wrong. They wanted the court to force me into compliance, collect the $25,000, and grant them the right to place a lien on my property if I didn't pay. Eviction was no longer implied. It was written. I hired an attorney the same day. Not because I doubted my position, but because arrogance collapses fastest when it's forced to argue in daylight. My lawyer didn't need long. He reviewed the documents, smiled once, and said, "They're going to regret filing this." The first hearing was procedural. The HOA's attorney spoke confidently, outlining how my ranch benefited from nearby HOA-maintained roads and utilities. He implied shared access, shared responsibility, and shared obligation. None of it held up to scrutiny, but he delivered it smoothly, like someone used to opponents folding early. When it was our turn, my attorney didn't argue. He presented. He submitted the deed, showing no covenants. The survey confirming the boundary line. County maps establishing zoning separation. Historical records proving the HOA had never maintained, serviced, or governed the ranch. Not once, not ever. The judge asked a single question: is there any document tying this property to the HOA? There was a pause. The HOA attorney tried to pivot, talking about fairness, community benefit, and precedent. The judge stopped him mid-sentence. That wasn't my question. There was no document. The judge ordered a continuance, instructing the HOA to produce any evidence supporting jurisdiction. They left the courtroom visibly shaken, their confidence suddenly brittle. Over the next few weeks, the pressure intensified, not from the court, but from the HOA itself. I received letters urging settlement, emails warning about prolonged litigation costs, a phone call suggesting we resolve this amicably before things became more complicated. Translation: they were bleeding money and hoping I'd flinch. I didn't respond. Instead, we prepared. My attorney filed motions challenging their standing, citing statutory limits on HOA authority. We requested discovery, maintenance records, infrastructure agreements, and financial statements. The HOA resisted. The judge didn't appreciate that. At the next hearing, the tone had changed. The HOA attorney spoke carefully now. Less theatrical, more defensive. The judge questioned why they'd pursued enforcement without a single binding document. He asked how they calculated the $25,000. He asked why eviction was mentioned at all. There were no clean answers. Then came the turning point. During discovery, it became clear the HOA had attempted this before, with other landowners near their boundary. Most had paid. None had gone to court. The ranch was simply the first property whose owner refused to be intimidated. The judge wasn't angry. He was unimpressed. By the end of that session, the HOA's claim looked less like a legal dispute and more like a pattern. A strategy. One that relied on pressure rather than proof. The judge scheduled a final hearing and warned the HOA's counsel to carefully consider their position moving forward. Outside the courtroom, their attorney asked if I'd consider settling for a reduced amount. I declined. Because at that point, this wasn't about money. It was about drawing a line, one they had already crossed. The final hearing was scheduled for a Monday morning, the kind that strips away drama before it ever has a chance to form. No packed gallery. No media. Just a judge, two legal teams, and a case file that had grown thick with evidence the HOA wished didn't exist. By then, their confidence was gone. What remained was obligation. They had pushed too far to retreat quietly. The HOA attorney opened carefully. No grand claims this time. No talk of community benefit or implied inclusion. Instead, he leaned on technical language, suggesting that boundaries could be interpreted flexibly and that the association had acted in good faith. It sounded less like an argument and more like an apology disguised as persistence. The judge let him speak, then asked him to sit down. My attorney stood and did something devastating in its simplicity. He walked through the timeline. Purchase. Survey. First letter. Demand for $25,000. Threat of eviction. Filing of suit. He didn't raise his voice. He didn't editorialize. He let the facts stack themselves until the pattern was impossible to ignore. Then he addressed the heart of it. HOAs, he explained, are creatures of contract. They have no authority without consent, no power without documents, no reach beyond the land that explicitly binds itself to them. There was no ambiguity here. The ranch had never been annexed, never been amended into the covenants. never benefited from HOA infrastructure. The association had simply decided it should apply and acted accordingly. The judge leaned forward. He asked the HOA attorney to explain how an association could threaten eviction against a landowner with no contractual relationship. The attorney tried to argue deterrence. The judge interrupted him. "That's not enforcement," the judge said. "That's coercion." The room went still. The judge continued, pointing out that eviction is an extreme remedy, one tied to tenancy and contractual default, not a scare tactic to extract money. He questioned the $25,000 figure, noting there was no formula, no assessment schedule, no justification. It was, in his words, a number selected to compel compliance. That was it. The ruling came swiftly. The court dismissed the HOA's claim in its entirety. Not partially. Not conditionally.
Completely.
The judge ruled that the HOA had no jurisdiction over the ranch, no legal basis for fees, and no standing to pursue enforcement of any kind. He went further, stating that the eviction threat was improper and warned that similar actions in the future could expose the association to sanctions. Then came the part they hadn't expected. The judge granted my motion for costs. The HOA was ordered to reimburse legal fees. Not $25,000, but enough to hurt. The gavel fell, and just like that, it was over. Outside the courtroom, no one spoke at first. The HOA board members avoided eye contact, their attorney already flipping through his phone, calculating damage control. They didn't look angry. They looked exposed. For them, the loss wasn't just legal. It was structural. Their authority had been tested in a place where assumptions don't survive. And the result was now public record. For me, the feeling wasn't triumph. It was relief. Not because I'd won, but because the ground beneath my feet was solid again. The ranch was mine, unquestionably, and no letterhead or invented rule could change that. A week later, the HOA withdrew all claims against nearby properties.
Quietly.
No announcement. No explanation. Just a sudden end to a practice they'd relied on for years. The ranch went back to being what it was always meant to be: open land, clear boundaries, and freedom earned the hard way. They had demanded $25,000 or eviction. What they got instead was a ruling that ensured they'd never make that demand again. And that, more than anything, was worth the fight. The fallout didn't arrive with noise or outrage. It arrived in adjustments. Small, careful ones, like a system suddenly aware it had pushed beyond its limits and needed to retreat without drawing attention. Within days of the ruling, the HOA's tone across the entire area shifted. Notices became shorter. Language softened. Words like mandatory and enforcement disappeared from correspondence altogether. For me, the first sign was a certified letter marked Resolution Notice. It acknowledged the court's decision, confirmed that my property was not subject to HOA authority, and stated that all records referencing the ranch had been corrected. No apology. No admission. Just compliance, thin and reluctant, but legally binding. I framed the ruling and placed it in a file cabinet, not out of pride, but out of habit. Land ownership teaches you that clarity is something you preserve. Paper matters. Silence doesn't erase overreach. Documentation does. Neighbors started acting differently, too. People who had previously kept their distance now waved more openly. A few stopped to talk along the fence line, careful to stay on their side. They didn't ask about the case directly, but the relief was obvious. Someone had finally said no, and the system had listened. One man admitted, quietly, that he'd paid a similar assessment years earlier just to avoid trouble. Another said he'd been warned not to challenge the HOA because they always win. The court ruling changed that narrative. Not because it was loud, but because it was final. The HOA didn't dissolve. It didn't collapse. It recalibrated. That was more dangerous for them than any punishment. They now had a line they couldn't cross again, not without consequences that would follow them beyond their neighborhood. I returned to work on the ranch with a different awareness. Every fence post I replaced, every gate I repaired, felt anchored. The threat that had hovered over the land was gone. No more letters. No more drive-by inspections. No more people pretending proximity meant control. One afternoon, I noticed new survey markers placed near the boundary. Bright, unmistakable. Whether the HOA ordered them or the county didn't matter. The line was visible now. Undeniable.
Permanent.
I never contacted the HOA again. I didn't need to. The absence of interference was the victory. Not dominance. Not humiliation. Just the freedom to exist without being challenged by people who confused power with permission. What stayed with me most was how easily it could have gone the other way. If I'd paid. If I'd hesitated. If I'd assumed resistance wasn't worth the effort. The HOA had counted on that. They'd built an entire revenue stream around the assumption that intimidation worked. It worked until it didn't. The court didn't just rule on my ranch. It disrupted a pattern. One that relied on complexity and fear rather than law. And once that pattern was documented, it couldn't be quietly repeated. The land felt bigger after that. Not physically, but conceptually. The boundary lines meant something again. Ownership wasn't a suggestion. It was a fact. As summer approached, cattle grazed without interruption. Trucks came and went freely, and the ranch returned to the kind of steady, unremarkable existence it had always promised. That was the real reward, not the ruling, but the return to normalcy. They had tried to fold the ranch into their authority. Instead, they learned the difference between proximity and jurisdiction. And they wouldn't forget it. Time has a way of finishing what courtrooms begin. By the end of that year, the case felt distant, not because it lacked importance, but because its effects had settled into permanence. The ranch no longer felt like something I needed to defend. It simply existed, unquestioned and undisturbed, the way land should when ownership is clear and respected. The HOA never contacted me again. Not once. No follow-up letters. No policy updates. No thinly veiled attempts to reopen the conversation. Their silence wasn't courtesy, it was strategy. They understood now that attention was dangerous. That my property was no longer a target, but a boundary they were better off avoiding entirely. What surprised me was how far the impact traveled. Over the next several months, I heard from other landowners on the outskirts of the development. People who owned parcels near HOA lines. People who'd paid questionable fees years earlier because they were told they had no choice. Some asked how the case went. Others just wanted to confirm something important, that saying no was possible. The ruling gave them language. Confidence.
Proof.
One man told me he'd pulled out old documents and realized his land had never been included either. Another said the HOA had stopped sending him letters entirely after the case became public record. The pattern was unmistakable. The moment authority is challenged successfully, it loses its ability to intimidate quietly. I didn't become an advocate. I didn't organize meetings or file complaints. I simply shared what mattered. Read your documents, know your boundaries, and don't assume a letterhead makes something true. That was enough. The ranch continued to improve. Fences were reinforced. The barn roof was replaced. The land responded the way land always does when it's cared for, patiently, honestly, without agenda. Every improvement felt like an affirmation that the fight had been worth it. Occasionally, I drive past the HOA neighborhood on my way into town. The manicured lawns and uniform mailboxes looked the same as ever. From the outside, nothing had changed. But I knew better. Inside that structure, assumptions had cracked. A precedent now existed that couldn't be ignored. They would be more careful now. Not because they'd grown wiser, but because they'd been corrected. The case taught me something simple but powerful. Intimidation only works when it's unchallenged. The HOA had relied on complexity, legal language, and fear of escalation. What they hadn't accounted for was someone willing to meet them where those tools lose power, in court under scrutiny with evidence. They demanded $25,000 or eviction. They ended up paying to be told no. There was no celebration when I realized the full scope of it. No sense of victory. Just a quiet satisfaction that the land was finally free from interference it never should have faced. The ranch didn't care about rulings or lawsuits. It cared about rain, soil, and time. And now, nothing stood between it and those things. On some evenings, standing near the fence line as the sun dropped low, I thought about how easily fear could have rewritten this story. One payment, one signature, one assumption left unchecked. That's all it would have taken for the HOA's version of authority to become permanent. Instead, it stopped here. The boundary held. And that was the ending I valued most. Not the court order, not the reimbursement, but the certainty. The knowledge that ownership, when grounded in fact, doesn't bend to pressure. It waits. It holds. And eventually it prevails. The ranch remained outside the HOA, exactly where it had always been.